Good afternoon, everybody. Aaron Keller here on the Law and Crime Network, and welcome to those of you listening on Sirius XM satellite radio. We're talking about the Shaun Harrison case out of Boston, the case of a preacher who was also a school administrator who is accused by prosecutors of living a double life. He was anti-guns, anti-gangs, anti-violence, anti-drugs. On the surface, the accusation is that he shot a student in the back of the head. That student claims that the student was dealing drugs for that defendant, Shaun Harrison. He also faces a couple of other charges related to the possession of drugs, firearms, and ammunition. Gary Gerstenfield is an attorney from Washington, D.C. He's on the line with us. Gary, just very quickly, some of the evidence in this case is really stacking up against the defendant. You've got a number of witnesses on the stand. And even if you don't believe their stories, look, the police found drugs in the searches of this guy's apartment, as I understand it. So juries seem to like that when you've got tangible evidence that matches up some of the stories here.
One of the biggest problems as a defense attorney you have when you represent particularly young people is that there's very little effort on their part at concealment. They do a terrible job of it. And so you're right, the evidence is stacking up, but that's not unusual when you're representing young people because they tend to be very conspicuous from a lack of experience in life. And I guess maybe this theory that they're just not going to get caught, so they don't need to worry about it.
That's exactly true, Gary. We've got to take a quick break, though, in just a second here. So let's pick this conversation up where we're going to leave it off. We hope to bring you back to the Shaun Harrison case very soon here on the Law and Crime Network. But first, this. And welcome back, everybody. We're going to take you back live to the Shaun Harrison case in the Boston, Massachusetts area, the case of a preacher and school administrator accused of living a double life as a drug dealer. He's on trial for charges of armed assault to murder, illegal possession of drugs, firearms, and ammunition. On the stand right now, Chris Finn, a firearms expert, and you can see the exhibit on the screen. It's a diagram of the inner workings of a pistol. So let's listen live to court. And welcome back, everybody. We're listening into the Shaun Harrison trial in Boston, Massachusetts. It's a trial where a school administrator and preacher is accused by prosecutors of living a double life. They say that he was dealing drugs and even asking for help from students to help him deal drugs. He ultimately is accused of assault to murder charges, along with weapons and firearms, drugs, and ammunition charges related to the conduct that investigators uncovered after he allegedly shot one of his drug-dealing students in the head. That's the accusation. A lot of the witnesses on the stand thus far have been experts and fellow students in that school on the south side of Boston. We're going to take a break. We'll be back with more in the Shaun Harrison case from Boston, Massachusetts when we return here on Law and Crime. Welcome back to the Law and Crime Network, everybody. I'm Aaron Keller. I'll be with you for the remainder of the afternoon hours here. And welcome again to those of you listening on Sirius XM satellite radio. We're talking about the Shaun Harrison trial in the Boston, Massachusetts area. It's a case where a school administrator who is also a preacher is accused of living a double life as a drug dealer. He's facing charges related to the shooting of one of the students who ultimately survived that shooting and said, look, my school administrator asked me to help deal drugs, and ultimately, I know he's the one who shot me in the head. The victim directly pointed the finger at the defendant and said, this is the guy. Did the jury believe it? That's the question. Gary Gerstenfield is an attorney in the Washington, D.C. area. He's here with us on Law and Crime to break this case down. Gary, it's powerful in a courtroom when a victim is shot in the head, survives, and then gets up there and extends his arm all the way out and points and said, that's the guy who did it. I know him, and I know he's the guy who pulled the trigger. Did that leave a big mark on the jury, or do you think that some of these witnesses have credibility issues?
Well, it's a two-part question. So let's start with the easy part. Is the jury going to believe that Luis Rodriguez is telling the truth when he says, yeah, the guy who shot me is my teacher? Yeah, of course, they're going to believe it. But it's totally credible. It's as bizarre as it sounds. Yeah, it's a very, I mean, look, he was shot. That's not in being challenged. Where he was, where he got shot, is not being challenged. And the person who did it, he's identified that person is doing it, and that person doesn't have a terrific alibi to explain that he isn't the guy that did it. So that answers that part. The second question, he says, well, these people all have some credibility issues. Yes, they're all in drug dealing. And unfortunately for prosecutors, the sad reality is, and for defense attorneys as well, is, you don't get to pick your victims, you don't get to pick the witnesses, you sort of get what you're stuck with. But when a young person, he's 20 years old, testifies about being shot in the head, didn't expect it happening, and boom, he gets shot. There's a sincerity in the way he's talking, which is extremely credible.
Yeah, and we've seen other trials like this. I'm remembering one out of Boston that we covered last year where that child's body was found washed up on the shore of a beach across Boston Harbor. And the witnesses in that case had serious credibility issues, but the jury believed them when they pointed the finger and said, this is the guy who did it. And, oftentimes we're sitting here wondering, okay, well, is it the real story or was just this the easiest to believe story? And that's the one that prosecutors ran with. In this case, it's not a dissimilar situation, although the victim is very, very different and the charges are different. Here, you have the old saying, that, as I think you pointed out, that prosecutors really can't pick their witnesses. But here I think the deciding factor might be some of the physical evidence that in the mass of photos that we saw flip through on the screen, investigators did find marijuana somewhere where they were searching this particular defendant. So it's like, okay, unless we're to believe that the drugs fell out of the sky somewhere, why is it that this guy who is a preacher and a school administrator, why is it that he wound up with these drugs somewhere in his business? And that just, tends to lend credibility to the statements of these witnesses on the stand, the students who were also involved in the drug trade. But look, they say that this guy had this stuff, and lo and behold, police found it. So if I were on the jury, I'd say, hey, look, the physical evidence matches the testimony.
Look, anytime you have someone being accused of a crime, there's always the argument that whatever was found on me was staged, or there's an innocent explanation, or heck, it's just marijuana. I mean, come on. So, no, it's not as if Shaun has no defense potentially at all in the case. The problem is that collectively all this evidence against him is very, very compelling. And the other problem, of course, you always have is an alibi. Wherever we are, we're somewhere. And we know when Rodriguez was shot, so we have a time, we have a place, we have an identity of who. And if that person says it wasn't me, well, then he needs to come up with an explanation as to how it wasn't him because he was doing something else. He was somewhere else. Exactly.
I think we've got testimony resuming in the Shaun Harrison case out of Boston, Massachusetts. There's a firearms expert on the stand, Chris Finn. Let's listen to some of what he has to say. Okay, folks, sorry about that. The feed from the courthouse in Boston is frozen up again. We're talking about the Shaun Harrison case, the case of a school administrator and preacher who's accused by prosecutors of living a double life. They say that he was really dealing drugs involving students in drug dealing and that he ultimately shot one of those students in the head. That student survived and testified in this case, pointed at the defendant and said, yes, that school administrator, Mr. Harrison, is the one who did indeed shoot me in the head. Critical testimony ultimately leading to charges of armed assault to murder and illegal possession of drugs, guns, and ammunition for that school administrator and preacher, Shaun Harrison. We're going to try to get that feed situation straightened out from the courthouse in Boston. In the meantime, Gary Gerstenfield is on the line with us here at the Law and Crime Network. He's an attorney in the Washington, D.C. area. Gary, this case is going to boil down to some of the expert testimony, and we've been watching that go by. It's a little bit dry, but ultimately we're getting an expert on the stand who's a firearms expert. He pulled out a long gun, some bullets, and a 9mm pistol and said that he examined those. My guess is that what we're getting at here is this attempt to try to line up the striations on the bullets with the ones that were actually used in the shooting to say, yes, indeed, this is the gun that fired those bullets. But we've heard from a number of other people in the past that that science is by no means an intricate or an exact science. Yet we see it in trial after trial here.
So absolutely, and Aaron, it's good to be with you again. So the absolute top of the line Cadillac of scientific evidence is DNA. DNA is the gold standard, and everything else is less than. And by the way, including fingerprints. You know, there's still not even a consensus of how many agreements you have to have comparing one fingerprint to another fingerprint to say, in fact, that those are the same or made by the same finger. So the Cadillac of of DNA evidence, that's the top of the line. Striations, markings in a bullet, it is admissible evidence, and what can be argued is how much weight do you give to it. Bullet came from a specific gun. There are experts who say, yeah. There are experts who say yes, and
your feed's starting to break up a little bit, Gary. We're going to try to work on that and bring that back. We have to take a break, though. We'll be back with more in the Shaun Harrison case when we return here on the Law and Crime Network. Okay, folks, we just heard from the judge that they're going to take lunch now in the Shaun Harrison case. So while we wait for things to pick up, Gary Gerstenfield is on the line with us. He's an attorney in the Washington, D.C. area. He is helping us break down this case. Gary, we just had some rather strange testimony there about what could potentially slow down a bullet. I guess air pressure, humidity, in theory, can influence the speed at which a bullet would travel. But, I mean, does it really influence it that much?
Well, one of the problems with having an expert on the stand is they're experts. They know a lot about this particular area, and any area they're talking about, I mean, normally you talk about bullets and guns being fired. That stuff sounds pretty sexy, pretty interesting until you get an expert to start talking about it, and the next thing you know, that lunch hour is becoming pretty attractive, and, it's all you can do to keep your eyes open. Here's the takeaway that I think that is important. I think the testimony the prosecutor does want to bring out, and that is this. Can they connect the bullet to the gun? And that's pretty simple stuff, but not necessarily as easy as people might think. And the reason why is because firing a bullet from a gun doesn't necessarily give you anything. And what I mean by that is that, well, the bullet is fired from the gun, and then it hits a target, and then it disintegrates, and it gets damaged. And so you end up with less than a pristine object that you're now trying to compare against the gun or against another bullet that was fired in pristine condition, usually into a water tank. And now you're trying to compare these two objects to see whether you can make that comparison. Experts can never say for sure that one bullet was fired from the same gun that another bullet was fired from. The best they can say is that there's what they call sufficient agreement, because they're looking for different markings, or what we call striations, and they're trying to say that, yeah, there's enough markings on this particular bullet. And again, you're never looking at a pristine bullet. Someone's been shot, and for example, in our case, Mr. Rodriguez was shot in the head. They had to remove the bullet from his body. That bullet's not going to be in pristine condition. So they're comparing what was left of that bullet against what is hopefully at least a pristine bullet, and then trying to see if they have sufficient agreement to be able to make that comparison. Obviously, the prosecutor is going to make that argument, and the defense attorney comes back with his expert, and that expert can say, no, there's not enough sufficient agreement, the markings there's not enough of them. Now, an interesting thing that's in an effort to try to combat this problem, particularly in California, and I think we're going to see it spread throughout the country, is the idea of trying to put what they call microprinting on the part of the gun that's called the pin. That when you fire a gun, a pin hits the bullet, and the bullet then fires from the gun. From the compression. Well, if you could microprint, if you could put an impression on that pin itself, put a little number, a micro, going to be looked at by a microscope, then you'd be in a much better situation of identifying that bullet actually was fired from that particular gun, because the bullet actually will have micro-printed on the back of it the pin number, and that would be excellent for identification. Job of applying sufficient agreement, a lot more agreeable.
Yeah, now that would be interesting. Of course, I can wait and see how people are going to try to mess with that technology, even if it is indeed passed in California. These things can be defeated in some way or the next. But look, the bottom line here in the Shaun Harrison case, you've got a school administrator who is also a preacher who had this anti-gun, anti-violence message on his public persona. And now he's facing charges that he shot a student in the back of the head after basically asking that student to help him deal drugs around the school and around the community. So we've got a serious accusation, charges that this defendant was living basically a double life, that he was saying one thing and doing the exact opposite. Really interesting case out of Boston. The victim testified, identified the defendant as his shooter. We're going to be back with more to break this case down when we come back here on Law and Crime. And welcome back, everybody. We're talking about a couple of different cases here during the lunch hour in the Shaun Harrison case out of Boston, Massachusetts. Another one of the cases we've been covering is the Tex McIver case, and that particular defendant was sentenced yesterday afternoon after he was convicted of felony murder charges, although he was acquitted on the top charge, the malice murder charge in the state of Georgia. We're going to break this down a little bit. Gary Gerstenfield is an attorney in the Washington, D.C. area. He's with us here for the lunch hour on the Law and Crime Network. Gary, we've been talking a lot about Tex McIver over the months it took for this case to actually go to trial. It was an interesting trial with some interesting witnesses, most of whom are professionals in the Atlanta, Georgia area. And look, ultimately, the jury did something that was rather interesting here. If we're to believe some of the media accounts that are coming out of local reporters in Atlanta, this was a total compromise verdict. A number of the jurors have come forward. One spoke to us here at Law and Crime. Others telling local reporters, well, you know, some members of the jury wanted that top malice murder charge. Some wanted something that was more like a recklessness charge. And after the judge told us to go back and try to iron out our differences, we just met in the middle on this felony murder, and that's what we decided. Does it make sense to you?
Yes, happens all the time, particularly when you get this last instruction from the judge, which is basically, all right, boys and girls, go back there and give us a verdict. And oftentimes this is what happens, these compromise verdicts. And as defense attorneys, we are very offended by compromise verdicts, and we want to go and appeal the compromise verdict. We want to challenge the compromise verdict, and the reality is they don't get reversed because it's a compromise verdict. That's exactly what a jury is supposed to do. 12 people go into a room and they each have their own view and their own opinion, and then they're supposed to come up with a consensus. That's a compromise. It doesn't sound fair. Certainly Tex McIver doesn't feel it's fair. And frankly, you know, from my standpoint, watching the trial and commenting on it, you know, this was a verdict that struck me very much. I was very surprised. I thought that his attorneys did a really good job, which I guess proves the point, which is you never know what a jury's going to do, and supreme confidence in your case is a dangerous emotion to have. In this case, more than anything else, for a defense attorney is a reminder, no matter how good you think your case is, you can still lose, and Tex McIver definitely lost.
Exactly. Well, one of the witnesses in the trial who was colorful, was memorable, was Danny Jo Carter, of course. She was in the car in the driver's seat when that gunshot rang out. Tex McIver said he pulled the trigger accidentally, but did admit that it was a volitional pull of some sort. In other words, his finger actually did move the trigger. It wasn't that the gun spontaneously went off or anything like that. Danny Jo Carter was in the driver's seat. She heard it. She described in the trial she lost her friend, who was the victim, Diane McIver, sitting in the passenger seat right next to her. She gave a statement at the sentencing hearing yesterday. Let's listen to some of that. That was a victim witness statement from Danny Jo Carter. And Gary, just reacting to that statement, very clear that she lost someone very dear to her. And you could almost sense some sting in her voice that she was just shocked that Tex McIver, who was the defendant and also her friend, had asked her to basically cover it up. I felt that she was still kind of shocked about that. Did you agree?
Oh, absolutely. And you know, the problem is when you ask somebody to cover something up, immediately that's consciousness of guilt. And, you know, whenever you ask somebody to retell or not tell the full story, boy, that plays badly. Those optics present a very bad impression, as they did in this case in the trial. Now, there's another side to that, which is that Mr. McIver was trying to probably retain the reputation that he felt that he had in the community. And so there is an explanation, an innocent explanation, as to why he did that. But of course, now that we've had this murder trial and there's been a conviction, and I don't think I really don't think that it's clear to everybody exactly what was really going through Mr. McIver's mind or what happened. After all, everybody's in the front seat, she's driving, and so certainly it was unexpected that, you know, the gun would go off. And so I think in her mind, there's still maybe some lack of clarity as to what actually Mr. McIver was thinking at the time. I don't think she's fully sure about that either. And I think that this trial has still left her in a great deal of confusion. And I think that that's probably why she said some of the things she said today.
Yeah, not only that, but it seems pretty clear that she doesn't really like this guy anymore and is okay with the sentence. Tex McIver himself, of course, spoke during his sentencing hearing. His speech has gotten a lot of criticism. We're going to review at least the first part of it starting out now. Statement from the defendant himself in the Tex McIver murder case out of Atlanta, Georgia. He faced a number of charges related to the shooting death of his CEO wife, Diane McIver. Gary Gerstenfield is still on the line with us. Gary, one thing that resulted in a lot of criticism from that defendant is he spent a lot of time talking about support that he has gotten from people in the community who wrote to him, but he did not spend a lot of time talking about how sorry he was for having the gun in his hand that basically led to his wife's death.
I mean, it does seem somewhat disconnected for him to sort of these meanderings, but in all fairness, it's the meanderings of really what is a destroyed man. And that he's not coming to terms with or not acknowledging his conduct perhaps can be explained by the fact that he is truly a destroyed human being. Now, what difference does it make? Is he going to get a lighter sentence? If he came forward and apologized and tears grew and all that, I don't think it makes any difference. Judges see that all the time, and frankly, they're, alligator tears. Is a man whose life as he has lived. This is a man of privilege, of wealth. He is the 1%, perhaps the 1% of the 1%. He is wealthy. He is very respected, admired. He has, his name is Tex McIver. I mean, what a name for a Texas lawyer. And he's got the ranch, he has the life, and he has the pretty wife. And, he's asleep in the back of his car. They go off the road. He wakes up. I think there probably was some sort of a racial rant that he probably went through, and he grabs the gun, and his wife is dead. Coming to terms with that as sentencing, one thing about Texas, your sentencings don't take long. I mean, you don't get months to prepare or months to acclimate. You go right to sentencing right away. And we're still dealing with a man who is still absolutely destroyed. I believe very much that through the entire trial, he felt a supreme confidence that he would prevail. Because throughout his entire life, leading up to this very moment, it's probably been defined by one thing, which is success. This man has had a remarkable, successful life, and I think he thought, and I think his lawyers thought, that he would do quite well in this trial. And I think having lost and now being reduced to wearing prison clothes and spending the rest of his life in an environment of steel and cement, surrounded by people that, frankly, are alien to him. It's a life that's completely alien to him. I'm not surprised that his commentary here is bizarre, and I think criticizing it, is misplaced. This is truly I would call this the meanderings of a truly destroyed man.
That's one way to put it. Well, we're going to hear a little bit more from Tex McIver, the second half of his statement, when we come back here on the Law and Crime Network. Okay, there was Tex McIver, the defendant who was convicted of felony murder in the shooting death of his wife, Diane McIver. In the second part of a statement he gave to the judge just before he was sentenced. Gary Gerstenfield is on the line with us from Washington, D.C. He's a criminal defense attorney. Gary, look, this basically was a chance for Tex McIver to get some things off his chest, apparently address some of his supporters, talk about his relationship with his wife. He seems to still feel her presence and still feel a connection with her. But ultimately, the judge had a mandatory sentence to hand down here.
Right. Garen, it's good to be with you again. Yeah, look, I mean, there's really nothing at this point for because of mandatory sentencing that we have in Texas, there's really not a whole lot that for example, Mr. McIver is going to say it's going to somehow reduce his sentence. It is an opportunity for him to say whatever it is that he pretty much wants to say. I was struck by the fact that he made the comment that he couldn't say everything he wanted to out of respect to some objectives by his defense counsel, and frankly, I struggled to try to figure out what it is he might say at this point that would be a problem for his defense counsel. This is a case where, as far as appellate issues are concerned, I don't necessarily see any, because it's a fact-based case. The jury heard the facts and then made a decision.
Well, I don't know, Gary. I disagree with you. I think that there are some. One of them is allowing the jurors to basically go down to the car and carry out their own experiments inside it, putting the vehicle into evidence after initially not putting it into evidence. I mean, I think that if there's going to be an appeal here, it's going to wrap up around some of that, and probably also involve some of these post-trial statements from the jurors saying, oh, well, you know, now that we really have basically read what those of us in the press have written about the law in the case, now we think, yeah, he probably shouldn't have been convicted of that. I see two particular vehicles for appeal here.
Sure. So let's talk about the car part for a moment. So, yeah, there may be a criticism for the court for doing that. But again, the issue is whether or not you believe that he intended to fire that gun, and whether and we have what's errors that are maybe committed by the court that are not substantial in the sense that they don't affect the outcome of the decision of the jury. And the second part is that the jury now sort of Monday morning quarterbacking their decisions. That has never been a good terra firma for appeals or compromise verdicts. What goes on in the jury room is sacred, and having second thoughts later in the experience I have, particularly in Texas, is that you're not going to have successful appeal on those issues. I wish you could, because certainly I've been in the receiving end where I've had jurors contact me and tell me that they, regret their decision and they wanted to go back and see if they could change something. And we've used that in an appellate process, but unfortunately, at least in my experience, we've never had any success.
Yeah, I think that the car issue speaks a little bit more to burden of proof. If the jurors weren't happy with the state explaining the trajectory and the state was trying to argue that this was a deliberate shot, that it was lined up deliberately, the jurors apparently didn't buy it from the state and felt like they needed to get in the back and do their own experiments. If the jurors have to do their own experiments, the state didn't prove the case beyond a reasonable doubt, in my opinion. And also on top of that, it raises confrontation clause issues, because the jurors are getting in and out of the car and then going in the back and telling one another, well, I saw it this way, I saw it that way. Well, wait a minute. They basically became witnesses for one another. And that raises a confrontation clause issue, because they're in there doing their own experiments, trying to line up if the gun was held in a way that would result in a deliberate shot to the victim. And they're telling one another in the jury room what they're finding, and they're doing it without the ability to be cross-examined. I see those issues with it. Could an appellate court disagree that those are big enough issues to raise an actual issue? Maybe. I'd have to dig into Georgia law on that. But that's what hits me at first blush. That's how I would attack it.
And I misspoke when I said Texas. I always get that Tex McIver. You're right, it is Georgia. But again, we're talking about physical inspection. And you always are going to have problems when you allow a jury to do what's known as a physical inspection and actually go to and look at a location where something happened, and then are able to make their own independent assessment. It does allow them then to create questions that are not brought out in jury and are not brought out before the jury and are not given full venting by the defense or the prosecution to fully explore. Again, the jury's job is to sit there passively and listen to the information and decide, and not to be involved in the actual inspection of evidence sort of on their own. But whenever you have physical inspection, which is sometimes permitted in trials, you always run that risk.
Exactly. Okay, look, let's listen now to the judge actually handing down the sentence for defendant Tex McIver after his conviction on felony murder charges. And that was the sentence being handed down by the judge in the Tex McIver murder case. Gary Gerstenfield is on the line here. He's an attorney in the Washington, D.C. area. He's been monitoring this case with us all along here on the Law&Crime Network. Sentencing was pretty much a foregone conclusion, Gary, because you've got the defendant here who was convicted of felony murder, and it carries a mandatory life sentence. If we still have you on the line, Gary, I'm not sure. I don't see you. Do we have you there?
Aaron, I'm here.
Okay. So it was sort of a foregone conclusion as to exactly what was going to go on there, but you know, the judge kind of admonishing Tex McIver, saying, hey, look, you were sort of rambling around here, but you didn't really apologize for what the jury convicted you of doing wrong. It seems like a fair thing for a judge to say in a situation like this.
Well, Aaron, you know, the comments that you made earlier, I think, were spot on. And you made that same observation, that he's not really apologizing for his conduct and saying, look, I'm sorry that I killed my wife, or, you know, I am responsible. I didn't mean it, but my wife is dead, and I'm the one that did it. So there's two responses to that. Number one is, wow, this would be a time to apologize. But number two is you have to reconcile yourself and wrap your arms around the idea that that's what you did. I'm willing to give Tex McIver the benefit that he just can't wrap his arms around that. And I got to tell you, I can't imagine, you know, I've had cases where I've had, you know, the kid gets left in the car and parents just can't wrap their arms around the idea that they caused the death of their child by simply forgetting that the kid was in the car. And they just can't wrap their arms around that they're the cause of that they are a murderer. And so I'll give him his peace. He's got life. He in all likelihood will pass away in prison. And like I said, the life that he's going to lead from, as he said, the last 100 and some days he's been in jail. The life he is now leading, the life he will lead, is bleak. It is a depressing, sad, you know, day of one day follows the next. There's no difference. Holidays don't change. You know, maybe visits occasionally. It is a bleak existence. He's going to prison for the rest of his life. It is a traumatic and sad ending to a person who, again, had this life of prestige and success and wealth. That he can't wrap his arms around what he did, and he can't wrap his arms around taking responsibility at this point in his life. I'll give him his peace for that for now.
Well, one of the attorneys said this was a sad day all the way around. I think that pretty much summed it up. Well, we're going to take another break. When we come back here, we're going to talk a little bit more about the Shaun Harrison case out of Boston, Massachusetts, the case of a school administrator and preacher who is accused by prosecutors of living a total double life. They say he was really dealing drugs and involved in guns, ammunition, weapons, you name it. More on that when we come back here on Law&Crime.